Okay, People versus Michael Kahn, file number 255401.
Here I go on behalf of the people.
And we're on behalf of Mr. Khan, Your Honor, Mr. Khan is present. We are both approaching the vote.
Set for status conference today. Mr. Brennan, can you tell me the status of this file?
I may have, plea agreement that's been reduced to writing. My client's going to be pleading guilty to the operating while intoxicated. As a third offense, the remaining counts would be dismissed. And the habitual offender third would be dismissed.
Ms. Cope, that is what the plea sheet indicates. Is that a correct statement?
It is.
Mr. Kahn, have you had an adequate opportunity to talk to Mr. Brennan about this agreement?
Yes.
Is that how you wanted to proceed?
Yes.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hand. Mr. Kahn, were you on any kind of probation or parole at the time of this occurred?
No.
Right, and you understand that by pleading guilty to operating while intoxicated as a third offense, the maximum possible penalty you could face would be up to 5 years and or a $5,000 fine.
Yes.
That maximum possible penalty in mind, what is your view to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. And you have the right to remain silent during that trial and not have that silence used against you. You understand all those rights. I do. Understand that you're giving up and waiving all of those rights by pleading guilty.
I do.
Also, you don't have any right to appeal the plea that you're making here today. If you wanted to try to appeal it, your only way to do that is by leave, and that means that you have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. You understand that?
I do.
Has anyone threatened you with anything? No. Has anyone promised you anything other than what we said here in court today?
No.
Is it your own free choice to enter this plea?
It is.
Are you pleading guilty because you are actually guilty of this crime?
Yes.
The information I have indicates this happened on January 31st of 2025. Is that the correct date?
Yes.
On that day, were you consuming some alcohol?
Yes.
And after you consumed that alcohol, did you operate a vehicle on an M72 here in Provincetown?
I did.
And did you have any blood or breath tests to determine the amount of alcohol in your system? Do you remember what that result was?
I'm not, I think it was what, 0.125 or, yeah, it was, oh, yeah.
It was over the 0.08.
Yeah.
Do you have any reason to doubt the accuracy of that test?
No.
That you consumed enough alcohol that you were intoxicated at that time?
Yeah.
Had you previously been convicted of operating while intoxicated back in 2001 in the 81st District Court?
Yes.
And also in 2003 in the 82nd District Court?
Yes.
Ms. Koch, are the people satisfied with the factual basis?
Yes, and for the record, the PBT was 0.61 and the lab was 0.203.
Mr. Vernon, are you satisfied with the factual basis?
I am.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Vernon.
By way of inducement, I did go over his sentencing guidelines with him. I explained to him that that was my evaluation of this, of the criteria and the facts associated with that. That my evaluation was this is no way binding on this court. That was in no way a part of this plea agreement.
Do you have any questions about that part of it? Ms. Koch, are the people satisfied that the court has complied with statute and court will not take this plea?
No, Your Honor.
Say no.
I'm sorry, yes.
Okay. Mr. Vernon.
I am satisfied with the court's.
That's okay. If you're not, you need to figure out where you went wrong.
No, I was reading my notes. We are correct, Your Honor.
Okay. Mr. Khan, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there's a factual basis to support a finding that you are guilty of this charge, the court will accept your guilty plea. We'll set this matter for a sentencing date. It's going to be in early September. It's important that you stay in touch with Mr. Byrne prior to that time. And then before you leave today, you're going to meet with someone from the probation department to set up a pre-sentence interview. Do you have any questions about that? Ms. Stefan, have you had a chance to go through the pre-sentence report and talk to Mr. Church about that?
I didn't know. I don't think I got one.
Huh?
On paper?
Mr. Church, did you go through the report with her?
We went over the recommendations. I didn't provide her a hard copy of the report.
Okay. Did you want to review that report before we get started?
Okay.
Okay.
I would actually like to withdraw my plea, take the trial.
Okay. What's the basis for withdrawing your plea?
That was originally the plan that I had wanted to do in the first place, was take it to trial.
You changed your mind, is that?
I didn't really change my mind. That was the trigger I was making a lot of court date too.
Okay.
I just didn't really think it was so I didn't really think you guys could.
Well, we had a really long hearing there.
Yeah.
So there's only a couple of reasons why you're allowed to withdraw your plea after the court accepts it.
Okay.
Number one, if there's an error in the plea taking process, in other words, if I forgot to do something that I was supposed to do, advise you of some rights that I was supposed to advise you of, if you didn't understand what was going on at the time. I'm confident that you understood exactly what was happening on that day.
Not really.
I know that's what you say, but to any rational person.
Okay, but I'm not the only one guilty in this situation. So that's why I want to take the trial.
Okay, I'm explaining to you why you're not going to do that. Because there was no error in the plea taking process, in my view. There's no reason for me to allow you to withdraw. So,
Well, I said that at the time, the last court hearing, because that's not what I wanted. I told you that at the time.
yeah, I hear you. I'm not going to allow you to withdraw your plea because, in my view, you knowingly, voluntarily entered into that plea on that day. So we're going to go forward with sentencing today. Would you like a chance to read that report before we do that? Yes or no? Okay. So, you want to take a second to get a copy that you provided to us? So, yeah. Yes. Now, did you have a clean copy of paper copy that you get?
I do, Judge.
Mr. Church will give her a paper copy. So, Mr. Van, if you want to have a seat in the courtroom there, you can, here's the report.
All right, let's talk about that. This hearing featured Michael Kahn, and it started off fairly routine, but ended with a sharp twist in tone and direction. Presiding over the hearing once again was Judge George Mertz, who handled the matter with his trademark composure even when things got bumpy. The first part focused on Mr. Kahn entering a guilty plea to operating while intoxicated, third offense. That's a 5-year felony. And both attorneys Mr. Bernard for the defense and Ms. Koch for the prosecution seemed well prepared. The plea deal included a dismissal of the second count and the habitual offender enhancement. Everything was cleanly laid out. Mr. Kahn acknowledged he had been drinking, had prior DUI convictions in 2001 and 2003, and on January 31, 2025, drove after consuming enough alcohol that his blood test came back at a shocking 0.203. That's more than twice the legal limit, well into dangerous territory. But Kahn was cooperative, confirmed he understood his rights, and pled guilty without issue. Judge Mertz walked him through the plea process methodically, ensuring he understood the consequences, the waiver of his rights, and that there were no hidden promises or coercion. Smooth sailing so far. Then we pivoted to another defendant unidentified in this segment, who was scheduled for sentencing but suddenly attempted to withdraw her plea altogether, and this is where things got interesting. She stated that her original plan had been to take the case to trial and that she didn't feel she'd been fully informed. But Judge Mertz wasn't buying it. He calmly but firmly explained that the law only allows a plea to be withdrawn after it's been accepted if there's a procedural error or evidence the defendant didn't understand the process. In his view, neither applied here, he reminded her rather directly that her plea had been knowingly and voluntarily entered at the previous hearing. She tried to argue that she wasn't the only one at fault and hinted at a larger issue, but Mertz held the line polite but resolute. She wasn't getting that plea back. Instead, the judge gave her the opportunity to review the pre-sentence report before proceeding. It was a fair move under the circumstances, but you could tell his patience was running thin, not in a hostile way, but more in a we're not going in circles kind of way. The courtroom remained orderly, though. The emotional weight ticked up when the second defendant insisted her original intent was to go to trial. You could sense she felt unheard, but the judge maintained control of the process without letting it veer into unnecessary drama. Defense counsel and the prosecution both stayed focused, and the procedural integrity was never in doubt. All in all, this hearing was a tale of two defendants. Mr. Khan's case flowed by the book, rights acknowledged, facts admitted, plea accepted. The second? More complicated. There was clear discomfort, possibly regret, but Judge Mertz stayed grounded in the law and didn't let the proceedings unravel. It was a lesson in courtroom limits, what can be revisited and what can't. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.